Please, my lord. I'm extremely sorry, my lord. And the 5-day-1 matter is there. In fact, let's say a Passover matter. Let's say specifically directed to come and today. Actually, the wrong order was first. The name was that Mr. Rupesh Kumar Khunte. In fact, in my list also, my associate's number is not there. List ଅଛି 11 item ଟା ଅଲଗା ଟିକେ order ହେଇଯାଇଛି ଗୋଟେ auction matter 30 ତାରିଖ ଦିନ ଅଛି auction, so the entire property will go. So as your lordship's convenience, I will not pay anything, but
No, it is fixed to 5th January. What is there?
no, it fixed January जो rupees ଖୁଣ୍ଟିଆ ବୋଲି ଯୋଉଟା ହେଇଛି ସେଟା nobody has mentioned, ମୋ ତରଫରୁ କେହି mention କରିନାହାନ୍ତି in that name. Lordship kindly say next is the list in item 11. Lordship kindly.
So when this matter will come on 1912, nobody was there. Somebody made a mention, and on his mention it was urgent.
Passover
whatever it may be. Now on 5th January when it come, you make a mention this name, what is there? You are forgetting that Shakespeare's what is there in the name.
Sir, 30 तारीख दिन अच्छी last option. This is the problem. I will not put your lordship in trouble, but this is the situation. Entire property will go. So
it's all right, Mr. Das. When the date is fixed, you have to file an interim application for advancing the date that you have not done. So you cannot do anything.
Sir, may I pray also one thing, like a very small prayer?
Yes.
So can it come in the vacation?
No, it is up to you. You make a mention before the vacation court, and if the judge agrees, then it can be listed in view of the urgency. File a petition and move in.
Normally, we would not mention, but this is the name was something else.
That is nothing else. Might have been.
Sorry, Malik. I'm extremely sorry because this is the situation that I mentioned.
Okay. Yes, next.
You are the leader of a bar. Everybody wants to assist you. You must be.
Pardon, madam, matter relating to gastric and sent to the medicine center. After vacation, madam.
After no, don't give the memo now. All right. Yes, next. Call me.
Supplementary daily. Item number 1.
May I please, Lordships? I am appearing on behalf of my senior Mr. Chandra. May I permitted to place, Lordships? Lordships, the applicants have been convicted under section 302 and 149 of the IPC. Totally, admittedly, Your Lordship, 25 witnesses were examined, and solely relying upon PW 14, Your Lordships, the conviction has been made. We have an IA for stay of realization of fine, Your Lordship.
So, is it your case that on the basis of evidence of a solitary eyewitness, the conviction cannot be based, or what?
It can be based, Your Lordships.
On what ground it can be based?
Lordships,
how the court will appreciate the evidence if it is a case of solitary testimony?
And clearly, Lordships, that may be that would be the confidence from the solitary witness, if it would be attracted by and with the help of some corroborative evidences, Your Lordships. If the chain of events are the same.
Admit, call for the trial court record. Sterilization of fine. Yes, next.
Item 2.
Which page it up?
Meet the Lordship. The appellant has been convicted under section 435 and 302 of the IPC, Your Lordship.
Admit, call for the trial court record.
Item 3. With a fresh acting melon. Under section 363, 376-2, 376A, 302-201, and 605 of the Act.
What is the sentence in court, madam?
Life, madam.
So is there.
Yes.
So you take notice also.
Yes.
Or admit, call for the trial court record for the notice for the. Since one of the offense of the appellant has been found guilty, is under section so and so, notice for. Yes.
Item 4.
May I please, Your Lordship? Conviction under section 376 surplus 2 surplus 1 and 450 of IPC, Your Lordship. Conviction of Under 376 is natural life and 25,000 fine, your lordship. And under 450 it is 7 year and 10,000 fine, your lordship. I file IA for stay of realization of fine and
For
bail.
the trial court report. Interim applications for bail and sterilization of fine to be considered after receipt of the trial court report. In the meantime, land counsel for the petitioners shall supply the deposition copies of the witnesses to the land counsel for the state. Yes, next.
Item 5.
Of course. I pray. Sentence कौन है इसी?
376 2 है.
अच्छा, मैं पॉक्सो ची.
मैं पॉक्सो रे.
Executed. But 3 years no. This will be given.
हाँ. जाओ भाई हाँ हार्ड ऐसा लगी तो डिले कौन कर देगा जो यूजुअल ऑर्डर ले एडमिट कर दिया तू है ना नोटिस कर देगा नोटिस टा स्टेट नहीं किन दो है ना ते पैनल लिस्ट दे लो गुडे वे नुआ पैनल फाइल सुपर ये द लिस्ट है थ्रू सीनियर एक पर्सन की सीनियर एडवोकेट दे दो Look, Mrs. Pamir of Saul and senior advocate is engaged at the microscopy for this one. So, if you want to engage Korauchi, then order a
Actually,
let you
I did speak when you are engaging a senior counsel. The briefing counsel has to be that organized. So you can't take it alone.
senior advocate out of the king of
That would be the Avas group, young blood.
Avas Manj.
Avas one, along with Avas one.
Along with Avas.
You told senior advocate Korea or duty?
Yeah.
Item 6.
The usual order for the intimation, which is free copy of the order be handed over to the Ms. Pamir of the so she found.
Item 6.
Need to notice for apprentice no speaking out of spot.
No responses, no rank has been
Yes.
received.
Malada.
You are telling?
In 3A.
Item number 6.
For petitioner?
For the petitioner.
So you,
Sorry, my lord.
you intend to file an application for amendment of that
6. Not item number 6. Appearing for the
item
petition.
number 6 order टा देखी जो नहीं कौन ही चला
आगे.
तो कौन लिखा ही चला
आई फाइल करे my lord. आई फाइल.
कौन है लाइए कहीं
आगे जस्ट आगे फाइल करके.
अच्छा फाइल कर ले.
फाइल कर ले बेटी फाइल कर दें आइए नंबर ही नहीं
नंबर है ये
कितना नंबर देखिए
कॉपी.
The London Council. What is your good name, London Council?
सूर्यकांत जेना my lord.
Suryakant Jena.
Again, appearing on behalf of Mr. Suresh Kumar Panda.
Suryakant Jena, Land Council appearing on behalf of Mr. Suresh Kumar Panda submits that as per the order dated 15/12/2025, an interim application has been filed for amendment of the writ petition, which has been numbered which has been numbered as IN number 23348 of 2025. Let the same be placed on record. Matter be listed in the second week of January 2026. Yes, next.
Item 7.
Disposed of this batch in section 14. So, similar order.
Okay, 14.
Man,
You are for the bank.
I'm for the bank. But the page 8 annexure 2, 7th November 24 to the IES.
Maybe there is a 14 application.
So 7th of November 2024, page 8 annexure 2.
It's numbered.
Annexure 1, page 8.
You obtain the status of the this writ petition has been filed by the petition ECB Bank Limited. For a direction, the opposite party number 1, collector and district magistrate Balango, for passing necessary order in miscase number 102 of 2014, 2024, which was filed by the petitioner bank under section 14 of the Surface Act, with a prayer for providing necessary assistance to him, to the bank, for taking possession of the secured asset, and further provide assistance for selling or be transferring the same under the provisions of the Surface Act. The Land Council for the petitioner has annexed the copy of the application filed by the bank under section 14 of the Surface Act as annexure 1 to the writ petition, from which it reveals that such petition was filed, such application was filed on 5/11/24.
7/11/24.
Just 7/11/2024. The Land Council submits that till date no order has been passed. Stop. It drew the attention of this court the order dated 21/7/2025, passed in WPC number 10628 of 2025, Bank of India branch versus State of Orissa and others, and a batch of writ petitions, wherein taking into account the provision under section 14 of the Surface Act and the ratio laid down by the Honorable Supreme Court in the case of R.D. Jain and Company versus Capital Fast Limited, reported in 2023, 1 Supreme Court cases 678. This court has been pleased to hold as follows. Report pursuant to invariably do achieve with petitions once. Land Council for the state has received the copy of the writ petition and seeks some time to obtain instruction regarding the status of the application filed by the petitioner bank under section 14 of the Surface Act. Please this matter on 6 तारीख of 6-7 तारीख on 7th of January 2026. Instruction be obtained in the meantime. Yes.
Item 8.
My lord, item 8, my lord, I'm appealing to VC, my lord.
Yeah.
On behalf of the Union of India. My lord, it may be taken up along with another matter, that is WPC number 33938 of 2025, my lords.
कौन है?
It may be taken up along with another similar matter, that is WPC number 33938 of 2025.
333
My lords.
93
8 of 25.
33938 of 2025.
My lords.
Land Council. Similar matter or same order has been challenged.
My lords. My lords.
Say this order dated 24/7/2024, which was passed by the Land and Central Administrative Tribunal.
My lords.
Similar order was passed in that case and it was under challenge.
My lord, in that case, my lord, the order dated 24/7/2024 passed by the learned Central Administrative Tribunal in OA number 445 of 2024. And my lord, in this case, my lord, the OA number is 444 of 2024.
Acha. These are connected matters or what?
My lords, my lords.
All right, the Land and Council. এটা কাহা না লেখা हो?
Mr. Milan Kumar, on behalf of him, I am appearing.
Mr. Milan Kumar, Land and Central Government Council or what?
My lords, my lords.
Government Council. ଅଛନ୍ତି ତ କୋର୍ଟରେ?
My lord,
କୁଆଡେ ବାହାରକୁ ଯାଇଛନ୍ତି ବୁଲିବା ପାଇଁ?
on the way, my lord, he is on the way, he has not reached.
ଆରେ କଟକରେ ଉପସ୍ଥିତ
My
ଅଛନ୍ତି ତ?
My lords.
ମିଲନ କୁମାର, Land Council. अच्छा लेखिदिनुहोस् wants to appearing for Milan Kumar एमटी गरिदिनुहोस्. So that's that WPC number is of 33. This writ petition is connected to WPC number 33938 of 2025. And therefore the matter will be listed as on the said writ petition after ensuing Xmas holidays. This matter in the second week of January 2026 with the WPC number 50 also please of purchase. Yes.
Item 9.
Order of the minute. Central Administrative Tribunal is under challenge. Confirming the findings of the disciplinary authorities, appellate authorities, also the revisional authority. Annexure 1 is the order.
You have filed the entire pleadings before the.
My lord.
So let us your prayer in the original application, that is Annexure 11. Come to the relief sought for. Let us see what was your prayer.
Page 72.
Yes, 72.
To pass the order of punishment passed by the disciplinary authorities. Second is to pass the order by the order dated 9/10/2020 and 9/16/2021 under annexure such and such passed by the appellate and revision. Third is to direct the respondent to restore the pay and position in the seniority as station superintendent.
What sort of punishment was imposed on you?
Punishment, my lord, will come to
Annexure A4 series. Revision the punishment.
Yes, sir.
Is that punishment?
Punishment is at page 35, 55 and 36.
35, 36.
Annexure 5. 36 is the relevant. Reduction from the speaking order I'm placing.
Relevant part dekhantu.
Page 36 is speaking order. Reduction from the post of station superintendent in level 7 of 7 CPC with pay of rupees 60,400 to that of station manager in level 6 of 7 CPC with rupees 35,400 for a period of 5 years on expiry of the said punishment.
Why such punishment was imposed on you? Or what was the allegation? What were the charges?
Charges, my lord, will come to page 28. Article of charges claim.
Page 23 para 10. Page 23 para 10.
23 para 10. Okay, you read from paragraph 10 of page 23. That is there in the charges has been mentioned. Impugned order of the Land and Central Administrative Tribunal.
The charges against the applicant was for leaving the station without permission by the SCR and thereby not maintaining devotion of duty and acting in a manner unbecoming of railway servant in contravention of Rule 3, Sub-Rule 1, Clause 2 and Clause 3 of the Railway Services Conduct Rules. Every railway employee are bound by the terms of his employ to obey the general and departmental rules. As per GR 2.08, no railway servant shall, without the permission of his superior, absent himself from the duty or alter his appointed hours of attendance or exchange of duty with any other servant or leave his charge of duty unless properly relieved. That is my submission that it is admitted fact that the applicant left the station without intimating or permission from his superior. He is working in a sensitive post where he is responsible for life and security of not just national property but also human beings. Therefore, he ought to have been extra vigilant and careful while discharging his duties. GR 6.0.
What was your posting?
Station superintendent, my lord.
What कौन तादेरे perform करिवे कौन duty कौन
Duty मारे तो over
station superintendent
my lord.
कौन perform करिवे अपन duty? What was the duty assigned to you?
To look after the train schedule, my lord.
Train schedule.
The inquiry report साठी annex of 4th, my lord, may see.
No, your duty was to look after the train schedule.
My lord.
That was only duty.
And to allot, my lord, the train lines for from one station to other.
So, is it not a sensitive post?
My lord.
So, how can you leave your duty without intimating anybody and your authority and taking due permission?
My lord, at that particular time, my lord, I was suffering from ill health.
Illness बेले कौन छाड़ी पळेबे आपण जो दायित्वटा देइछंती से दायित्वटाकू एते बड़ से सेहि पई कहउछंती it was a sensitive post and there is question of life and security of not just national property but human beings also.
Numerous life and property would have been.
You will leave that place without intimating. Who will discharge your duty?
My lord, I had intimated, my lord,
What is your explanation?
My lord, my explanation was that due to ill health, loose motion, I was compelled to post leave station. That is also the conclusion by the inquiring officer.
Whatever it may be, somebody you have to intimate somebody or your authority, higher authority, or merely because there was some health problem, you will remain absent without intimating, particularly when you are holding such a post where this life of the citizen, the national property are at stake.
Before the matter of disciplinary authority, I have also annexed my evidence, my lord. I have admitted my negligence. Before this honorable court, my lord, I am only pressing for reduction of my penalty. They have imposed my.
That para 11 deals with that. Para 11 deals with that. How will you get over? Proportionality of the punishment. Just see para 11.
Violation of GR misconduct of conduct rules and shows lack of diligence to duty for which the charge memo was issued to the applicant. Violation of conduct rules are justifiable ground for initiation of disciplinary proceedings. The IO disciplinary authority just clarified the rules with the applicant which amount to misconduct and hence impose the punishment. In every case, giving right to tortious liability, tort consists of injury and damage due to omissions, stroke commission, duties and obligations recognized by law to avoid conduct fraught with unreasonable risk of damage to others. Not following the rules which while performing duties and omissions involve an unreasonable risk of harm to others. Not following the rules as provided would mean careless conduct in commission or commission of an act connoting duty from a breach and damage caused or to be caused to others. Duty of care is therefore crucial to understand the nature and scope of tort of negligence. Negligence in discharge of duty, where consequences are irreparable or resultant damage is heavy, which is the exact case in hand as discussed above. Act of the applicant exhibits lack of devotion and negligence in the performance of duty, and thus applicant has acted in a manner prejudicial to the interest of the authorities, violating the GR and in contravention of railway services. Considering the gravity of the entire incident, which could have led to loss of numerous life and property, these tribunals do not find the punishment shocking or
This is the reasoning.
That is the main reason.
Loss would have been irreparable. Numerous life would have been lost.
But a train the class is
Subsequently, sir, I went to the my lord will see the inquiry report. So I also, my lord, after I joined the service, immediately I left the station for 10 to 15 minutes. Then, my lord, I came to the station and by motorcycle, my lord, stopped that vehicle, my lord. Train to Agua station or Similarly, my lord,
like that. Fortunately, no unfortunate incident took place, but the question is that it could have happened.
my lord.
You
There is a
know that
negligence.
what happened in Bahanaga. And so 200, more than 200 people died. Little in such matters, how can you be so careless? କାହାକୁ intimation କରିବେନି ଏତେ ବଡ଼ post hold କରିବେ signal ଇଏ ସବୁ ଆପଣଙ୍କ control ଅଛି ଆପଣ ଛାଡ଼ି ଦେଇ ପଳେଇବେ କାହାକୁ intimation ଦେବେନି and they have just your reduction of pay କରିଛନ୍ତି ଆଉ ତ କିଛି କରିନାହାନ୍ତି you are still in service.
The message has to go.
Other, my lord, other guard, my lord, who was also facing disciplinary authority.
He is a guard.
Guard, you are 14, my lord, he was imposed minor penalty.
Oh, he is a guard. You are super. Why should the lower officers will be penalized for the misconduct of senior officers?
You are to overall see that everything. So
generally it is import for the junior officer. It is the reverse.
This writ petition has been filed by the petitioner Udaya Chandra Samal, challenging the impugned order dated 26/3/2025 passed by the Learning Central Administrative Tribunal Cuttack Bench Cuttack in OA number 265 of 2021. Along with the order stated 1/8/2019, 10/9/2020, and 9/16/2021, passed by the Disciplinary Authority, Appellate Authority, and Revisional Authority, respectively, with a further prayer to modify the punishment imposed upon the petitioner by directing the opposite parties to consider the imposition of a minor penalty consummate with the nature of alleged loss in parity with similar cases where lesser punishment has been awarded, and to restore the petitioner's pay, seniority, and consequential service benefits in accordance with such modifications of punishment. Stop. The petitioner filed the aforesaid original application wherein he sought for following relief. Quote paragraph number 8 to page 72. The opposite parties filed the counter affidavit wherein it is stated inter alia, paragraph number 4 onwards ତାକୁ short କରିକି ଲେଖିବେ 4 to up to 18 ପର୍ଯ୍ୟନ୍ତ ତାକୁ short କରିକି ଲେଖିବେ. The petitioner filed the rejoinder affidavit wherein stand has been taken, that will be short very little from paragraph number 2 to so on. Stop. It appears that by a speaking order, after the charges leveled against the petitioner was found to be proved, the authority concerned decided for reduction of the petitioner from the post of SS in level 7 of 7 CPC with pay of rupees 60,400 to that of level 6 of 7 CPC with 35,400 for a period of 5 years, on expiry of punishment period, which will have the effect on postponing the future increments of his pay and also loss of his seniority to meet the ends of justice. Stop. The memorandum of charges, the memorandum of charges reads as follows. Page number 28 the petitioner submitted a representation and disciplinary and the inquiry report was submitted. On the basis of such inquiry report, the punishment was imposed, which is euthanasia. When the original application was filed, notice was issued to the opposite parties, and the opposite parties filed the counter affidavit wherein the stand has been taken without appeal, and the petitioner filed the rejoinder affidavit. After hearing the learning counsel for the petitioner and the opposite parties and going through the pleadings, the learning tribunal has been pleased to hold as follows. Quote paragraph number 10 and 11. The learning counsel for the petitioner submitted that the punishment which has been imposed on the petitioner is grossly disproportionate to the act alleged to have been committed by the petitioner, and therefore it needs modification. Stop. However, after going through the pleadings and the charges, the inquiry report, we find that the petitioner was holding a very sensitive post where he was responsible for life and security of not just national property but human beings. And in view of the specific guidelines provided in GR number 208 that no railway servant shall, without permission of his superior, absent himself from duty or alter his appointed hours of attendance, or exchange duty with any other railway servant, or leave his charge of duty unless properly relieved. Found that the petitioner, by remaining absent unauthorizedly without intimating his superior authority, has contravened the provision, and the negligence in discharge of the duty would have resulted heavy damage, and the conduct of the petitioner exhibited lack of devotion or negligence in the performance of his duty. If the petitioner suffered from ailment suddenly, he should have intimated the higher authority so that someone else could have been posted, assigned the duties of the petitioner, which has not been done in the case in hand. Therefore, we are of the view that the disciplinary authority, the appellate authority, as well as the revisional authority was justified in holding that the petitioner has acted in a manner prejudicial to the interest of the authorities, violating the GR and contravention of the Railway Service Conduct Rules 1966, which indicates that if a railway servant that every railway servant are bound by terms of the employment and to obey the general and departmental rules, and they should maintain devotion of duty and should not act in a manner unbecoming of a railway servant, in contravention of 3(1) bracket 2 and 3 of 1966 rules. In view of the findings arrived at by the London Tribunal, after hearing the London Council for the petitioner, who don't find any infirmity or illegality in the conclusions arrived at by the London Tribunal, and therefore there is no merit in this writ petition, which stands dismissed. Yes, next.
My lord, appeals will be notified. Deepak Uchan, please. On the chat. What do you want? Appeals may be noted. We are for the opposite participants. Oh, please.
Next.
Item 10.
TPCODL matter. TPCODL. Restoration of power supply player.
Item 11.
Rule 20 of the Income Tax Certificate Proceeding Rules of 1962.
What is the prayer in this writ petition?
Sorry, my lord?
What is the prayer here?
The prayer in the writ petition is to quash an order which has been passed without jurisdiction.
No, debt recovery tribunal.
Yes, by the recovery officer. By the recovery officer, against which appeal lies to the PO, but there are multiple applications pending before the PO prior to filing of this particular applications, which even though are being heard, no orders are being passed.
No, we are directing you. Which order you have?
No, there are multiple orders. I'll just bear with me for a minute, my lords.
You are challenging the order dated 1/12/25.
1/12/25, but prior to that, I had also challenged. Your Lordship may kindly see the flag. Just two orders, Your Lordship may see. And this is a certified copy of the paper book.
You come to the conclusion part.
I'm coming. Before that, Your Lordship may kindly see this. How the proceeding has been conducted. This is a certified copy of the records of the DRT.
No, you see the recovery officer's
Yes.
order.
Recovery officer's order
is to be brought to the notice, is to be challenged before the.
I have challenged. That is exactly what I'm trying to show to Your Lordship. Your Lordship may kindly see this. Paper book, Your Lordship may see. This is the proceeding of the DRT.
This order is dated 1/12/2025, you say.
Yes.
Where have you challenged the order?
Not this order. Prior to this order, there were other orders which I have challenged.
Read that order. You see that.
This order is irregular in the sense that on the self-same ground, Your Lordship has the recovery, subsequent recovery.
Before the DRT.
Sorry, my lord.
Raise it before the DRT.
My lords, if the DRT hears me, I have no difficulty. But the DRT is not, even though his hearing is not passing an order, he is not making an order. That is my difficulty. That is my predicament, my lord. Your Lordship may kindly see this.
By challenging the orders one, so needless to say that the order can be challenged before the line DRT. Mr. Mukherjee submits that similar orders have been earlier passed.
It's not similar orders. Earlier orders in the same proceedings.
Earlier orders have been in the same proceeding.
Have been assailed before the presiding officer, which are
has been assailed before the presiding officer, but no order has been passed there. It is expected that if the order is challenged before the DRT at an earliest, preferably within 15 days from today, the same shall be disposed of at an earliest in accordance with law, according to
and till such time, let the sale not be affected.
The interim application is filed, but not affecting the sale. The same shall be considered in accordance with law. Yes, next.
Item 12.
May I please, my lord? Decision, the petitioner is the borrower of the bank, that is ICICI Bank Baripada branch. And
what has happened, Learning Council?
That
why have you come? What is the difficulty?
Challenging the procedural system which has to be.
No. What is the stage now? 13-4 has come.
13-4 has not been complied, and after completion and taking possession of the securitized house, thereafter, my lord, the notice has been served. Thereafter, that is annexure.
Prayer number 2.
Annexure.
Prayer number 2. Why without
that without serving notice to the borrower, immediately this action has been taken, and the articles are also inside the house, and no chance has been given. The borrower was not present. His wife and old cancer.
Challenging before the DRT. Why are you come?
Because no notice was served, Your Honor. This is the illegality. I am challenging the legality.
That you say, but it may be that the bank may say that who is appearing for the bank? ICICI Bank? You are appearing. So who is appearing for ICICI?
And now, my lord, the date has been fixed on December 26. The house will be sold by auction. That is, my lord, that has been provided through the WhatsApp messenger. Now, so my respectable submission, my lord, that the auction may kindly be stayed.
No, and go before the DRT. You are served with a notice under 13.2. You have submitted 13.3. You have submitted your representation. Then
no,
13.4.
No representation has been submitted, and yes, no 13.3. 13 clause 3A is to be a chance to be given to the borrower, but no chance has been given. And on 21st September, the house has been taken possession.
Yes.
Thereafter, the notice has been given on 23rd September, and that notice has been issued by the petitioner, my lord, on 7th October to comply with the provision of Securitization Act.
When the possession was taken?
Possession was taken on 21st September 2025.
What you are doing till September or December? What you are doing? If your possession has been taken since
Without
September,
serving the
what you are doing and why have you not earlier come up?
I have filed this application, my lord, on 18th October.
No. This application has been filed 18th October. If there is any urgency, you should have moved earlier. Today is the last date before the Xmas holidays, and the bank is not there. How can we know that whether the 13-4 notice has been issued or not? Because the possession has been taken from you and since September, and you have got the alternative. We cannot touch it in view of the decision of the Honorable Supreme Court.
Yes, my lord. In view of this provision of law, my respectable submission, my lord, that the getting notice under provision 13 clause 2 is a mandatory one. That notice has not been served
There
upon
is
the
no
borrower.
dispute. If it your case that 13-4 notice has not been issued, but possession has been taken, all these things, and this was taken in September. Why are you sleeping? Why have you not earlier moved the application? Why are you coming on the last date?
The borrower represented before the bank through the higher authority.
You submit an application before the branch manager. You serve a copy so that he may appear and apprise this court whether the 13-4 notice has been issued or not.
No notice has been issued, and I have a
this petition has been filed by the petitioner Maniranjan Pradhan.
Annexure 2
with the following prayers, for the entire prayers. The main contention of the petitioner is that no notice has been served under section 13.2 and 13.4 of the Surface High Act on the petitioner, even though the possession of the mortgage house was taken on 21/9/2025. And therefore, the prayer has been made to restore the possession of the secured assets to the petitioner. The possession of the mortgage property has been taken on 21/9/2025.
Auction.
It seems that this writ petition was filed on 18/10/2025, and the matter was listed for the first time on 25/11/2025, and there were defects, and the London Deputy Register J. Lozima asked the London Council for the petitioner to remove the defects, and accordingly the defects have been removed. Therefore, it shows that there was laches on the part of the petitioner to take expeditious step in getting the matter mentioned to take off at an earliest. Today is the last date for before the ensuing Xmas holidays, and in view of number of decision of the Honorable Supreme Court, that in case such and such Surface High Act proceeding has been taken, this court should not entertain the writ petition, and since there is alternative remedy available for the petitioner. Be that as it may, since a prayer has been made, specific stand has been taken on that there was no notice under served under section 13.2 and 13.4 of the Surface High Act. Let a copy of the writ petition be served on the branch manager of ICICI Bank, Baripada branch, and by day after tomorrow, and the matter be moved before the vacation bench uh, uh, so that the court can
If court reproduction survives. If court reproduction survives.
To know the correctness of the averment taken in the writ petition, and to pass necessary order. Yes, next.
Item 13. May I please your lordship? My lord, in this present case, originally the property belonged to Raja Birokipur.
7 cases.
My
What 7 cases? This is
My-
one case.
no, in the present case.
Present case.
I'm sorry, I beg your pardon.
Yeah.
My lord, originally the property belonged to Raja Birokisur Dev. Then thereafter the property sold to one Braja Kishore.
Here what has happened?
My lord, here in this case,
13 to notice issue.
my lord.
Then what you have done?
My lord, after the 13 to notice issued, the present petitioner got to know that the same property is now registered in the name of Sri Jagannath, and the Matkodar is the Jagannath Mandira Administrative
This
Trust.
13-4 notice has been also issued on 18/11/2025. You have stated
13-4 notice not issued, my lord.
that you have stated that on 18/11, you come to page number 28.
Okay.
On 18/11/2025, the authorized officer had taken the possession of the secured property in exercise of the power under 13-4. So you have to go to the DRT. Why will entertain this?
My lord,
This writ petition has been filed. Yes. From the averments taken and the documents filed, it appears that on 18/11/2025, the authorized officer had taken possession of the aforesaid secured property in exercise of the power under section 13(4) of the Surface Act, read with Rule 3 of Security Interest Enforcement Rules 2002. Mr. Nalini Kanta Das and his associates have filed power for the ICICI Bank, and the London Council has produced the order dated 9/7/2025, passed by the London District Magistrate and Collector Puri under section 14 of the Surface Act, in directing the Tahsildar from Executive Magistrate Puri to take over the possession of the secured assets, observing stop the in view of the later produced, since alternative efficacious remedy is available to the petitioner in view of the decision of the Honorable Supreme Court, the petitioner is at liberty to take recourse to so and so. It is made clear that we have not expressed any opinion on the merits of the case. Yes.
Annexure 5, there's a
Raise all those points. It's like
Special notice for delivery of order, CRLS 4.3 of 23, CRLS 629 of 23, CRLS 758 of 23, CRLS 1141 of 23.
Keeping in view the scope of granting bail to the appellants, as discussed above, we find that the Lennon trial court, in the impugned judgment after discussing the evidence of the doctor conducting autopsy and giving opinion that the cause of death of the deceased was due to shock resulting from hemorrhage as a result of injuries to the head, chest, and abdomen, which were antemortem in nature and sufficient in ordinary course of nature to cause death, and that all the gunshots injuries were possible by bullet injuries, came to hold that the death of the deceased was homicidal in nature. The Lennon trial court also discussed the evidence of each of the prosecution witnesses, the ballistic report, the TI parade identification of some of the appellants, as well as the identification in court, the recovery of the weapon of offense, and particularly considering the evidence of the eyewitnesses, came to hold that the prosecution has successfully established the offense under Section 302 of the IPC. The criminal conspiracy part was also discussed, and it was found to have been successfully established by the prosecution. Similarly, the possession of the firearm by the appellant was also discussed, and the Lennon trial court has found that the prosecution has successfully established the charges under the Arms Act. Though the Lennon counsel for the appellants raised various contentions as to why the testimonies of the eyewitnesses should not be believed, so also the criminal conspiracy. However, if such arguments are dealt with in detail at this stage, we are of the humble view that the same is likely to have some effect on the merits of the appeals and it would ultimately prejudice the appellants. Therefore, we do not propose too much of discussions and elaboration on the points agitated while considering the plea of suspension of sentence pending appeal. If an exercise is made for detailed examination of the evidence touching upon the merits of the case, it would not be proper and justified. In the case in hand, keeping in view the nature and gravity of the crime, the nature of evidence adduced by the prosecution during trial, the criminal proclivity of the appellants to commit heinous crimes, we find no sufficient ground for grant of bail to the appellants pending disposal of the appeal, as the same would not be in the interest of justice. Accordingly, all the interim applications, that is IN number 926 of 2023, 1366 of 2023, 2097 of 2023, and 2508 of 2023 in CRLH number 423 of 2023, 629 of 23, 758 of 23, and 1141 of 2023, respectively filed by the appellants, stand rejected. The appellants Tulia alias Nigamananda Jena and Bablu alias Nihar Ranjan Das alias Patnaik, who are on bail, shall surrender before the Land and Trial Court forthwith, failing which the Land and Trial Court shall take coercive steps for their arrest and after their arrest commit them to judicial custody. However, taking into account the period of detention of the appellants in judicial custody, if any applications are filed by the appellants for expeditious hearing of the criminal appeals, the same shall be considered in accordance with law.
I agree.
Obliged.
Obliged.
Will be uploaded today.
Yes, yes. Next.
Item 14.
Item 14, my lords, limited prayer for the petitioner, my lords. That is a prayer time. Appropriate direction may be issued for compliance of the order dated 4/9/2024, Annexure 1, my lords. Paragraph 6 of that order, my lords. Lordship directed the learned DRT Cuttack to expedite the hearing of the SA number 67 of 2022.
Have you brought this order to the notice of the court?
Yes, Lordship.
Where have you stated?
You have not even filing the proceeding before the DRT.
Where have you stated that you have brought the notice of the court and what happened thereafter? Where is the order sheet? Once an order has been passed in the writ petition directing expeditious disposal, is it not required that you should bring it to the notice of the DRT?
My lords,
writing a memo.
My lords, paragraph 5 of my petition, my lords.
Come here. Come.
Paragraph 4, my lord. Paragraph 4. In the meantime, long time has elapsed since the production of the certified copy of the aforesaid order passed by this honorable court before the DRT Cuttack. More than 1 year and 3 months has
What is the order sheet, Land and Council? It is just a mere averment. Where is the order sheet which must be reflecting that you produced the order sheet and it came to the knowledge of the DRT and thereafter the case was not expeditiously disposed of. You produce that order sheet and thereafter what has happened?
Filing the proceeding.
The entire proceeding after the production of the certified copy, as you said, you produce it, will take a...
My lord, first
this petition has been filed by the petitioner with a prayer for early disposal of SA number 67 of 2022 pending before the Land and DRT Cuttack. The Land and Council for the petitioner, Mr. Rao, submitted that earlier the petitioner approached this court in WPC number 20624 of 2024 with a similar prayer, and this court by order dated 4/9/2024 has been pleased to direct the London Tribunal to expedite the hearing of the essay number 67 of 2022 and make every endeavor to dispose it of within 3 months from the date of production of the certified copy of the order if there is no legal impediment. Stop. Ground has been taken in paragraph number 4 of the writ petition that long time has elapsed since the production of the certified copy of the order passed by this court before the London DRT, but the London DRT has not paid any heed to the aforesaid order of this court for disposal of essay number 67 of 2022. However, the order sheet of the London DRT has not been filed to show that such an order was passed and what was the reason for which the London Tribunal could not dispose of the essay at an earliest. Stop. The London Council for the petitioner seeks some time to produce the entire order sheet to show that the order was order passed by this court was brought to the notice of the London DRT and the order sheet following the orders passed thereafter. Put up this matter. Kebe rakhiwa kuntu? Mr. Raut.
Second week of January, Lordship.
Second week of January. Yes, ask date for the second week of January 2026. Yes, next.
Item 15.
I pray some time to file one document has been
You not filed OA copy.
the OA copy I filed, the MA copy you could not file and attach. That is why I seek some time.
The London Council for the petitioner submitted. Counter has not been filed.
No, but it's a fresh case.
No, we are telling you that before the
on the ground of limitation it was rejected.
On the limitation point,
Yes.
it was
Yes, on the ground of limitation, the tribunal is rejected after 2 years they have come. After getting the information from
what
RTI,
you
they are-
intend to file?
One MA has been filed along with the original application.
Acha.
That I have not annexed. That is
Yeah, MA for condonation of the
yes, true.
the London. This writ petition has been filed by petitioner Namita Varik, challenging the order dated so was filed by the London Central Administrative passed by the London Central Administrative Tribunal in OA number so. The Land Council for the petitioner. You are Mr. Sahoo.
Yes, madam.
Mr. Narinikanta Sahu submits that one miscellaneous application was filed before the London Central Administrative Tribunal, MA number
326 of 2023.
326 of 2025.
Yes, sir.
And inadvertently they said MA could not be filed and some time may be granted to file such the copy of such MA. You are appearing, Mr. Panda?
My lord,
Mr. Panda, London Central Government Council, along with Mr. Swanso is present. You have given a copy.
Copy has
Copy of the writ petition has been solved. Is this matter?
2 weeks time.
Second week of January 2026. Yes, next.
In the meantime, whatever we filed, sir, copy will be
A copy of that may be also solved on Mr. Panda in the meantime. Yes, next.
Item 16.
Item 16, I am for the petitioner. Just for I am for the cabinet, just to solve the copy of the cabinet.
What happened to you?
Follow me.
Who threw Pande?
Accident.
Accident. Scooty चलाउथले.
गाड़ी चलो कार डोर टा खोल देले.
अच्छा. Fracture ହେଇଛି ନା କଣ? Compound ଚାହୁଁଛନ୍ତି?
Just to fix the date by 6.
କେବେ କୁହନ୍ତୁ ନା ଆପଣ?
6th of January.
6th of January. On the consent of Land Council for both the parties, lays this matter on 6th January.
Give it copy.
2026. You have given a copy to this one.
Just
stated by the Land Council for the petitioner that the copy of the petition has already been served on the Land Council for the caveat. Then 6th January 2026. So next.
Item 17.
Please, your lordship, I'm appearing on behalf of the petitioner. Petitioner is a senior citizen and with permanent disability. Your lordship, the e-auction was conducted on 5th of December. But before the date, your lordship, the complete principal amount was arranged by the petitioner. But under
What is the result of that e-auction?
Auction was with permission. Auction was held for an amount of rupees 75 lakhs 10,150 on dated 5th December 2025.
So what happened?
Lordship, they refused.
Peter has already deposited that amount.
Yes.
Where is the document?
Milord, I have obtained the
So you are to go to the DRT.
DRT, Milord.
No, Lordship. Under 13A of the Surface Act, it clearly states that the provided that the reason so communicated or the likely action of
raise all those points before the learned DRT alternative forum.
Lordship, but it is written that any right shall not confer any right upon the borrower to prefer an application under the
petition
DRT.
has been filed challenging so and so. Mr. Puna Saul and counsel for the Bank of India submits that
Milord, Union Bank of India.
Union Bank of India submit that in the meantime the auction sale has been made successful and the successful bidder has deposited the bid amount in view of so and so decision since alternative remedy.
Our representation was ignored under 13A. Lordship.
Take that grounds there.
That ground is
Yes, next.
Item 18.
Obliged.
Yes.
Made placement. This arises out of a recruitment process in response to an advertisement made in the year 2012. Then during the pendency of this, during the ongoing recruitment process, Milord, the act.
Mr. Mahanti, why are you challenging a 2016 order now?
Milord, we are challenging because we are appointed in pursuance of that selection. Now in 2024, the High Court has passed the order. Milord, your Lordship will kindly have a glance at that page 200.
Annexure 9.
Annexure 9.
Yeah.
245. Has your Lordship got it?
Yes, sir.
On cumulative assessment of the materials placed on record and discussions made herein above, this court only finds the direction of the tribunal quashing the corrigendum to be erroneous, and accordingly such finding of the tribunal is directed to be set aside. Further, the consequent direction not to provide age relaxation to the in-service candidates in terms of is also set aside. So that part of the order has been set aside, and then Milord, now thereafter it has failed before the Honorable Apex Court, Milord. In Annexure 11, your Lordship will see thereafter a contempt petition was filed. In inviting reference to the subject, I am directed to say that the following information may be furnished. Now the department is taking an action to re-evaluate the entire election process. My grievance is that we are duly selected, that there is a finding that there are 2 question papers, 2-3 questions out of the syllabus and wrong questions.
No, this judgment which was passed under
2016, I was not a party. We are the selected candidate. I was not a party before the tribunal, nor before the High Court. Your Lordship, I only pray that now that I cannot challenge the election process, it has gone to the Supreme Court and the judgment. I only pray that your Lordship may kindly have a glance.
If you are not a party, then how this judgment is binding on you?
Exactly, Milord.
See, that is what our
non-gender is already, Milord. We don't think judgment, Supreme Court.
Your Lordship will. I will not go that far.
This is appealed by Supreme Court now.
Huh?
Appointment by Supreme Court. Upheld by Supreme Court.
That is so.
No, that is not upheld by the Supreme Court. Going to that arena, my lords, will make the matter complex to join the friend, my lords.
Yeah, I am telling you, one of the unsuccessful candidate went to the apex court. That is,
but the veracity of that judgment was gone into by the division bench, and now the Supreme Court has declined to interfere.
Yes, declined to interfere.
Can we test the judgment today?
No, we are not asking your lordship to test the judgment. We are only telling Lord that according to the various decisions of the Honorable Apex Court and also this Honorable Court, I have already rendered 10 years of service. There is no allegation that I have committed fraud or malpractice or there was anything wrong in my field. I have answered the wrong questions rightly. I have answered the question.
Now, what prevent you to approach the DRT by filing? Sorry, DRT tribunal by filing.
I was successful. I was given appointment. Where was the scope for approaching the tribunal?
Where is the cause now? What is the cause?
Cause is that apprehension of termination. So the apex court ratio of various decisions are given to your lordship.
On the basis of apprehension, how can we interfere? There should be some order passed.
No, that is, my lord. It is
there is apprehension, then at the threshold you should go to the tribunal. Because the orders passed by the tribunal,
there is no tribunal.
Central Administrative Tribunal, the order was passed by whom?
State. There is no cause of action at present, my lord.
So, my lord, 1 minute, my lord. Your lordship, say that the Supreme Court.
24
Supreme Court. Vikas Pratap Singh, my lord.
You come to that petition, annexure 11, page 248.
Yes,
and that is your main. You are apprehending, but
now what will happen? The age relaxation will be a zone of consideration.
But why are you saying that? Was that the common order then?
Your prayer. Your prayer is to pass that common order, which has not only been upheld by this court.
See the prayer of your petition.
You have to amend that prayer at least.
But now we are to join with the senior we are the only difficulty we are.
People kindly see the Honorable Apex Court has also told that where there is no fault of the incumbent after several years of service, it will be improper and equity says that
you are absolutely correct. But see the prayer. Can we pass it today?
Your lordship is sitting in an equity jurisdiction of 26.
Now,
you amend the prayer and bring the correct state. What is your application?
This is the last day.
Last day, that is not last. It doesn't mean that we'll pass an order.
And inartistic drafting.
No.
Inarticulate drafting of a petition will prevent the lordship.
So this prayer we cannot entertain. How can we issue notice?
Come to annexure 9. First paragraph. Annexure 9. What was challenged? The same order was challenged.
Same order was challenged.
Kindly see the first
part. That is right, my lord. I have seen.
Challenge of different petition, common order 23, 22, 3 to 2016.
Same order is challenged here now.
Same order you are challenging now, which has already been tested by division bench. Kindly keep Supreme Court. Annexure 9. 209. 209 first paragraph.
9 totally prayer ही 9.
First paragraph.
Please amend the prayer and
209 first paragraph.
We are not even trying to pass that order.
Ashok Madil and Senior.
And that some of the
Milord, we are only telling that let that exercise of re-evaluation goes, but let us be protected.
Some amendment is necessary.
We are not challenging any order.
The amendments, the repetitions also the prayer portion. And he intends to file an interim application. If any such interim application is filed, the same shall be placed on record. Matter will be placed after the ensuing Xmas holiday. Yes, next.
Then we can only request Mr. Naik These people are working since last 10 years. Don't precipitate it.
The petitioners were intervener in earlier writ application.
No.
Yes, that is kind
They
of
were working in any case. They are working for 10 years. You can hold on for 1 week. What is the big deal?
Yes, next.
Item 19.
19, item 19.
Can your lordship fix a date at least 6 or 7?
No, you can move. We can give a liberty.
You can move in vacation also.
It is open to the petitioner
Vacation also.
to file, move the application.
26th and 30th court is sitting. So you can
here.
Yes.
So during vacation.
Well, I thought Santa Claus will give some gift to Lord.
But you have to ask the right thing to the Santa Claus. You don't ask the right thing what to do.
Next, item number 19.
Item 19, may I please? Sir, liberty to guide you granted to move in before the honorable High
It has already stated that during vacation it is open to the petitioner to move the application. Yes, next. Item number 19.
Item 19, may I please, Lordship? In this case, bank is already taken possession of the petitioner land. May I liberty given to the petitioner to approach to the
Just wants of prayer of DRP, approve the DRP. Yes, next.
Item 20.
Item 20, may I please, your lordship? I am sorry, the copy was given today to my learned friend. So your lordship may take up on the reopening.
Mr. Mishra,
But he has got
taking
just an half an hour back.
the interim application for
As well as
amendment
the reproduction.
on the land council for the opposite party today and stop. Mr. The land council for the opposite party submits that he may be given some time to go through the interim application and matter be listed after ensuing Xmas holiday. Yes, please, this matter after Xmas. Next.
Obliged.
Item 21.
21.
My lord, it is regarding that amendment after closure of that proceeding before the ombudsman on 15/8/2000.
Saw the copy on Mr. Maharana?
Yes.
Pariji.
My lords, I'm there on VC, my lords.
Any objection to the interim application?
My lords, in
Yes.
fact, last two occasions, my lords, I was constrained to take an adjournment to file objection. I have served the copy to my learned senior over WhatsApp because he was not available yesterday.
No, I have received copy. And,
Yes.
He is received.
My lords,
You received the objection.
my lords, I'll just file it with your lordship's permission today, my lords, during course of the day.
You want to file it because it is not on record your objection.
Yes. Today
you have
we have
just
served
served a copy but not filed in
I'll file it, my lords, in
Mr. Maharana Land Council, IN number so and so. This is an application for amendment of the writ petition. As it appears, as submitted by Mr. Maharana, appearing to virtual mode that he is to file the objection to the interim application for amendment during course of the day, and he has already served a copy of the objection on Mr. Das Land Council for the petitioner, which is not disputed. Stopped. In case the objection is filed today, the same shall be placed on record and the matter be listed in the second week of.
I am without electricity. I have
This also the same may be moved before the vacation.
Unnecessary time is
vacation bench removed. Yes, next.
Item 22.
Let it be allowed, objection that formal in nature, that
no, he has filed the objection. That is not on record. How can we?
He could have filed it earlier, he has taken time twice.
Item 22.
Item 22.
He has done this.
What is the delay?
Delay 19 days delay.
What is this criminal appeal for?
Appeal is acquittal.
Same order challenged by the state, and in the meantime, leave granted and government appeal number 12 of 2025 registered.
No, it's all right, but since it's a appeal against acquittal and there is a delay, then a notice has to go. So let me do. IN number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 19 days. Issue notice on the question of limitation. Requisites for issuance of notice on opposite parties number 2 to 9 be filed within 1 week after reopening of the court after ensuing Xmas holidays. Stop. Copy has already been served on the Land and Council for the state. Matter be listed 4 weeks after. Objection, if any, to the delay condonation application shall be filed in the meantime. Yes, next.
Item 23.
Please. Will against the conviction.
What is the sentence imposed?
Life imprisonment.
For what offense?
302.
302. What is the delay?
44 days.
44 days. We are condoning, Mr. Khan. IA number on application for condonation of delay. Stamp reporter has pointed out delay of 44 days. Considering the amendments taken in the interim application, hearing the land council for the respective parties, and since case of conviction in which the appellant has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Heart admit call for the trial court record. Interim application for bail and stay realization of fine to be considered. After receipt of the trial court record, deposition copy to be supplied in the meantime. Yes.
Item 24.
Item 24 minutes, appeal against acquittal minutes. Delay of 56 days in filing the
56 days. IA number so and so. This is an application for condonation of delay. Issue notice on the question of limitation. Represents to be filed. जो पूर्व केस रे ज्यादा है ना 2 and 3 है ना. The counsel submits that he has received the copy. 4 weeks after, file the objection in the meantime. Issue notice says next.
Item 25.
May I please? There is a delay of 39 days.
What is this criminal appeal for?
302 in the life. 302 life sentence.
Conviction case. Conviction case.
Yes, nice.
All right. IA number so and so. This is an application for condonation of delay. 39 days delay and the same order. Delay condoned. Admit call for the trial court record. Interim applications so and so. We consider after receipt of the trial court record. Deposition copy to be supplied. Yes, right.
Item 26.
Item 26 was. Can you permitted to move this case on behalf of Mr. S.K. Singh, Your Lordship?
What is this case for?
Lord's appellant has been convicted for life under section 376M of the IPC laws.
All right.
The judgment was passed on 23.
Year number so and so. This is an application for condonation of delay. So and so for same for the 78 days delayed condone.
Notice.
376. Notice for the admit for the interim application for bail and stay to be considered after receipt of the so and so and deposition copy to be supplied. Yes, next.
Item 27.
This is my directed to government of the instructions.
What is
regarding conduct and
criminal antecedent and कौन अच्छी conduct of the petitioner in jail custody. कितने वर्ष रहिलानी?
4 years. 3 years, 11 months.
Conduct inside jail is certificate.
Now किसी criminal antecedent?
Only what will be on 30.
हाँ?
With agent case file.
अब किसी नहीं है. बाकी ये offense कौन?
302.
कौन अच्छी material?
Material, there is no direct evidence available, only circumstance evidence.
कौन circumstance अच्छी?
That at the time of death of his wife, he was in that room and he intimated.
You are the husband of the
husband.
How did death has taken place?
There is material, no material there, but from the examination it has come out that
homicide and sharp cutting weapon.
Sharp cutting weapon that has been screwdriver they have mentioned, and somewhere it has been mentioned by use of axe. Neither axe was produced nor screw was produced before the court.
All right, but this is not only you have stated that you have remained only for 3 years.
3 years, 10 months at present. 11 months ago.
Let it go after February 2026. For the next.
Item 28.
Kindly take out the matter after this.
After? Yes, after Xmas holidays.
Item
As prayed for.
Item 29.
Item 29, my lords, I have filed a bail application, interim application flagged A for bail. Pursuant to your lordship directions, I have entered my appearance.
Yes.
Lords, petitioner is in custody since 26/6/2020. This is an appeal against conviction.
How many years you are in custody?
My lords, almost more than 3 years, little more than 3 years. Date of custody is 26th of June 2022. and she's sentenced for life, 70-year-old woman.
So, what are the materials against you?
Well, what's material against me is the dying declaration of the victim, that in which she said that my client is the one who has hit her and killed her. So that is the one material. There is no direct evidence, no eyewitness.
3 years they have come after February 2026. Next.
Item 30.
My lord, this is for the interim bill on the ground of his wife is pregnant and state was to obtain instruction.
What instruction you have obtained? Expected date of delivery is
23rd.
Already taken.
Huh?
Already.
Already Pfizer and how have you been?
My lord, post-delivery care is needed, my lord.
Paternity leave.
Paternity is only for an interim bill.
ଆପଣ ଯାଇଥିଲେ interim bill
Yes,
ବାର
my lord.
ଦିନ ସେତିକିବେଳେ ଗଲା on verification of the criminal interim
There
bill.
are other criminal antecedent against the petitioner, but very interim bill there are.
Interim bill, he was engaged for something else.
Same thing.
So on 14/12/2025 ରେ ଆପଣଙ୍କର you have already a baby girl is there. So କଣ କରିବେ? ଏ ଛୁଆଟାକୁ ଯାଉ ଦେଖିକି ନା ଆସୁ 2 ସପ୍ତାହ ଖଣ୍ଡେ 21 କେବେ ପଡିବ 14/12 ହେଲେ ଏଟା ଫାଷ୍ଟ ଚାଇଲ୍ଡ ନା ଆଗରୁ ପିଲାପିଲି ଅଛି?
Second.
My lord, at least for a month.
କେତେ ଦିନ କଣ କରିବେ?
He has already surrendered in time when he was granted interim bill.
ଲେଖି ଦିଅନ୍ତୁ so and so application for interim bail as for the previous order, the land council for the state as for the written instruction received from IAC Saranpur police station and dated 24/12/2000 so that the petitioners the wife of the petitioner delivered a baby girl at Dorpo Narayanapur PSC on 14/12/2025 when counsel for the petitioner submits that the presence of the petitioner may be enlarged on bail to see the baby and take care of her health condition. When counsel for the state has no serious objection, 3 weeks bail granted. Next. Double date fix up surrender certificate करना. अब पासवर्ड अच्छी 10.
Passover item number 10.
Right, non appears after Xmas holidays.